Swayam Prabha. Digital India. Educated India.
Welcome to lecture number 11 of the subject Business Law, and the topic of discussion is Rights of Unpaid Seller. I am Dr. Rama Bansal, working as Assistant Professor at Arya College, Ludhiana. This project is sponsored by DTH Swayam Prabha, MHRD, New Delhi. Under the topic unpaid seller, we are going to discuss today the first of all the meaning of the unpaid seller, the definition, the rights of the unpaid seller against the goods, against the buyers personally, and then consequences of breach of contract of sale, seller's remedies as well as the buyer's remedies, and at last the auction sale. Let's start with the topic. First of all, we have to be very clear with the meaning of unpaid seller. Section 45 of Sales of Goods Act 1930 defines the meaning of unpaid seller. A person who has transferred the ownership of the goods or the property to the buyer but still has not been paid either in full or in part. The person, the seller, is known as unpaid seller. The payment which is due may be the whole of the price or the price in part. When a negotiable instrument has been received as conditional payment and condition is yet to be performed by the reason of the dishonor of the instrument, the person is not getting the payment, the seller is not getting the payment, and the seller has not been paid yet, the person would be known as unpaid seller. The seller remains unpaid till even a small portion of the price of the property transferred is left. When the whole price has been tendered and the seller refuses to accept it once, and then the seller will lose the title of unpaid seller because the buyer has offered him the price and the seller has refused to accept that. If there is a period of credit, then the seller is not will be considered the seller would not be considered as unpaid seller till the price of the good becomes due. So, we are clear with the meaning of unpaid seller. If I say the person who is not being paid in full or in part for the goods transfer, for the property transferred, the person is known as unpaid seller. And if the person is unpaid seller, then definitely he must have some rights with him to claim that money from the buyer. So, if we talk about the rights of an unpaid seller, these can be divided into two categories: against the goods, against the buyer personally. So, against the goods, the unpaid seller has the right of lien, right of stoppage of goods in transit, right of resale, right of withholding the property. But against the buyers personally, the unpaid seller has right to sue for price, right to sue for damages, and right to sue for interest. Let's discuss all these points in detail. Let's first discuss the rights of unpaid seller against the goods. Once the property is still in the possession of the goods but the ownership has been transferred, then the unpaid seller has these rights. The first right is the right of lien. It is under section 47 to 49, defined under Goods of Sales Act 1930. What is the right of lien? Right of lien is to retain the possession of the goods with the seller until the payment for those respective goods is not been made. Means when the seller is in the possession of goods and the payment is not made but the ownership has been transferred to the buyer, the seller, the unpaid seller, has a right of lien or lien of on those goods. But this right can be exercised when the following conditions are being satisfied or in the following cases. One, where the goods have been sold without any stipulation as to credit, means no credit stipulations were made, at the time of the contract. Now the seller is unpaid, where the seller have been sold on credit but the term of credit has expired. Say there was a time period of credit to pay for the goods for 3 months. Now the 3 months have gone and the payment is still not made, then this right can be exercised, and when the buyer become insolvent. Now the buyer has become insolvent and is not in a position to pay for the goods to the seller. Now in that case the seller has a right of lien on the goods, and this right of lien, it's important to know that, is linked with the possession of the goods, not with the title. The seller would not give the possession of goods, he would not transfer the goods personally to the buyer, but the title of the goods would remain with the buyer. The unpaid seller can exercise the right only when the goods are in his possession. If the goods are not in his possession, the right of lien cannot be incurred, cannot be exercised. There is a case of Barucha versus Vadhya, with which we can make this point more clear. Mr. A sold certain shares to Mr. B. The relatives share certificates and transfer forms duly signed were handed over by the seller to the buyer against payment of price by check. The buyer became insolvent. It was held by the Privy Council that the seller had no lien on shares because his lien ceased when he parted with the possession. That means, as this case also clears this point very clearly, that once the unpaid seller has aparted from the goods, aparted from the possession of the property, this right of lien cannot be exercised. Right of lien is indivisible in nature. That means the right of lien would be on the complete portion of goods. It cannot be on it cannot be for the proportionate price, it cannot be for the proportionate goods. Buyer is not entitled to claim the delivery of a portion of goods on payment of a proportionate price. That means if the seller is accepting the proportionate price for the proportionate goods, he cannot exercise this right further. This is also clear with this example. Mr. B sells to Mr. A sells to Mr. B a certain quantity of sugar. It is agreed that 3 months credit shall be given, but Mr. B allows the sugar to remain in Mr. A's warehouse till the expiry of 3 months and then does not pay for them. Mr. A may retain the goods for the price. That means if the whole quantity of the sugar is available with Mr. A, now he is not going to give any amount of the sugar to Mr. B. If this is being allowed, it would violate the right of lien with the unpaid seller. How the right of lien can be terminated? The right of lien is linked with the possession of goods. Once the possession is lost, the right of lien is lost. But the unpaid seller loses his right of lien in the following cases. 1. By delivery to carrier. Delivery to carrier for the purpose of transmission of goods to the buyer. When it is being operated, that means this unpaid seller has lost his right of lien. It is clear from the example. The goods sold were delivered to buyers' shipping agents who had put them on board a ship, but the goods were returned to the seller for repacking. While they were still with the seller on this mission, the buyer became insolvent, and the seller, being unpaid, claimed to retain the goods in the exercise of his lien. It was held that, having lost his lien by delivering to the shipping agent, his refusal to deliver was wrongful. That means once when he has delivered the goods to the carrier for the purpose of transmission to the buyer, that means he has lost his right of lien on the goods. Second is by delivery to buyer. That means once the unpaid seller has delivered the goods to the buyer, that means he has lost his lien of goods. Seller's right is not defeated where the buyer has obtained the possession without the consent of the seller. That means if by using some wrongful act, by using some wrongful means, if the buyer has taken the delivery of the goods, taken the possession of the goods, that means the seller's right is not defeated. Even the goods are in the possession of the buyer, the seller can still exercise his right of lien, because the goods are being transferred to the buyer without the consent of the seller. The buyer has done some wrongful act and has adopted the goods. Third is by waiver. If the seller by using his authority has waived his right, that means he don't want to possess the good with him, for not paying for those goods, the right of lien is terminated. A waiver is expressed when it is mentioned in the contract. That means when the contract was made, if it is being mentioned in the contract that in case of non-payment for goods, the goods cannot be held, the right of lien cannot be exercised, then it is a express waiver, and in this case the right of lien is terminated. A waiver is implied where the seller sells the goods on credit or grants of fresh terms of credit. Let's suppose there was the term of credit in the contract when the contract of sale was made, and on the day of the payment, now the seller has given 2 months more credit, let's suppose. So that means when the seller has given a fresh credit on the goods, on the terms of the credit, fresh terms of credits are being given, that means he has lost his right of lien on the goods. By tender of price means when the buyer tenders price for goods, the seller no more remains an unpaid seller, and when the seller is not an unpaid seller, he cannot exercise his right of lien. The second right of unpaid seller is the right of stoppage in transit, which is covered under section 50 to 52. Right of stoppage in transit means to stop the goods in transit. Means once the goods have been shipped by the seller to the buyer, now the unpaid seller wants to stop those goods in transit. That means he is using his right of stoppage in transit. That means the right can be exercised only under the following circumstances. One, the seller must be an unpaid seller. The seller must have parted with the goods, but still the buyer have not acquired it. Means goods are still in transit. These are apart from seller and apart from buyer too. The buyer must be insolvent, means the buyer should not be in a condition to pay for the goods. Only then the unpaid seller can use this right. This is clear from the case of Bethel versus Clark. Mr. B, who had bought goods from Messrs. Clark and Company of Glasgow, instructed the sellers to sell the goods by a certain name the ship to Melbourne. Goods were first railed to London and then shipped to Melbourne, a maid's name receipt being sent to buyers. On the way, Mr. B becoming insolvent, the seller gave notice to the railway company to stop delivery to buyers, but it was too late. Then they gave fresh notice to the ship owners claiming back the goods before the ship arrived at Melbourne. On arrival there, the receiver in bankruptcy of Mr. B demanded the bills of lading from the master, held the goods have been effectively stopped in transit and trustee could not claim them. That means once the goods are out of the possession of the seller and the buyer has not received the good till date, that means if in that between time, if seller exercise his this right of stoppage of goods in transit, this is a valid right with him. What we mean by duration of transit? Goods are in transit from the time when they are delivered to a carrier for the purpose of transmission to the buyer until the buyer takes the delivery. The period in between is known as duration of transit. The carrier may hold the goods for as a seller's agent in case seller has exercised his right of stoppage in transit, as buyer's agent when seller cannot exercise his right of stoppage in transit, and also as an independent contractor. The unpaid seller may exercise the right of stoppage in transit. How? by actually taking possession of the goods, that means he can goods back into his own custody, by giving notice of his claim to the carrier in whose possession the goods are at present. That means the carrier who is taking the goods to the buyer on behalf of the seller, the unpaid seller can give the notice of his claim to the carrier that the goods should be stopped in transit, means it should not be delivered to the buyer. So we have read with the right of lien and right of stoppage in transit. But what is the difference between these two? Let's see. First is possession of goods. What is the possession of goods? The right of lien can be exercised only when the goods are in the possession of unpaid seller. But the right of stoppage in transit can be exercised when the goods are not in the possession of unpaid seller. These both are different. Right of lien when goods are in the possession of seller, and right of stoppage when goods are not in the possession of the unpaid seller. Insolvency of the buyer. The right of lien can be exercised even when the buyer has not become insolvent. Means buyer is not insolvent but he is not paying, even then the right of lien can be exercised. But right of stoppage in transit can only be exercised when the buyer has been declared as an insolvent. Termination of right. Right of lien can be terminated as soon as the unpaid seller loses the possession of the goods. Means the possession of the goods is lost, right of lien is also lost. Right of stoppage in transit is terminated as soon as the carrier of goods loses the possession and delivered them to the buyer. Means once the goods are being given to the carrier to give the goods to the buyer, and once he deliver the goods, the possession is lost, the right of stoppage in transit is lost. Process of right. The essence of right of lien is to retain the possession of the goods, and in case of stoppage in transit, it is to regain the possession of goods. Here it is to retain, and in case of stoppage in transit, it is to regain the possession of the goods. What is the essential element? Essential element in case of right of lien is, it is a possession is the test of a right of a lien, and that is, if the possession is lost, right is lost. And in case of stoppage in transit, non-delivery of goods by the carrier to buyer is the test of right of stoppage in transit. Means if the carrier has not transferred the goods to the buyer, this right can be exercised. Third right of unpaid seller. First we have discussed with the right of lien. Second we have discussed with right of stoppage in transit. Third is right of resale. Under section 54 of Sales of Goods Act 1930, the right may be exercised in following circumstances. One, when the goods are of a perishable nature. Perishable nature goods cannot be retained for so long, so to claim the price, the unpaid seller has the right to resell them. Where the seller has exercised his right of stoppage in transit, he can give the notice to buyer of his intention to resell. Means once the unpaid seller has exercised his right of stoppage in transit, now he may intimate to the buyer that if the buyer is not going to pay in some specified period, he will sell the goods to the other customer. In case the buyer makes default, buyer is not going to pay any kind of money for the goods sold to him, then the unpaid seller has the right to resale. And when the seller exercises this right, the buyer who acquires goods title there's to as against the original buyer. The fourth right of an unpaid seller is a right of withholding delivery. That means this right is similar and coextensive with the right of lien and stoppage in transit. In this, the unpaid seller can withhold the delivery of the goods to the buyer, and this right can be exercised even if the sale was on credit or that the goods were specific or unascertain goods. That means in case of an unpaid seller has the right of lien, right of stoppage the goods in transit, right of resale, and right of withholding the delivery. Now we will discuss the rights of unpaid seller against the buyer personally. Till now we have read the rights against the goods. Now we are reading the rights of unpaid seller against the buyer personally. Number 1, suit for price under section 55. If the property has passed to the buyer and goods are in his possession, then the unpaid seller has only remedy for the price, because he has lost the possession of the goods. Now he cannot retain the goods, he cannot stoppage the goods in transit, he cannot resell the goods. But what he can do, he can only suit for the price of goods. Here the if the price is payable on a certain day, irrespective of the delivery, the seller may institute a recovery for a suit for recovery of the same too. Second remedy is suit for damages of non acceptance under section 56. If the buyer wrongfully neglects or willfully refuses to accept the goods or to pay for the goods, then the seller may exercise his right to claim to file a suit for damages for non acceptance of goods. Third is suit for interest under section 61, where the buyer wrongfully refuses to accept the goods and is not paying for them. Then the court may award interest on the price of the goods. That is the right of the unpaid seller. Means if the buyer has not paid yet and is delaying the payment, he can file the suit in the court for the interest on the original payment due. And this interest would be from the date of tender of goods to from the date when the price is payable. And in case the goods were sold on the credit, the interest will run from the expiry of the credit period. Let's say the goods were sold on 1st January, the credit period was on 1st March, and after 1st March, till when the buyer would not pay the payment, he has to pay the interest on the original payment. And seller is entitled for interest when he is in a position to recover the price. Means if in any suit it is being found that unpaid seller can't claim the price from the buyer, then he is also not able to get for the interest on the original amount. And if he can sue for damages for breach of contract, he is not entitled to interest. It's very interesting to know that once he has filed a suit for breach of the contract, in that case he is not entitled for interest. He can claim interest only in the case when he is filed a suit to recover the price of goods from the buyer. Now, what are the consequences of breach of contract of sale? They both have, because the breach can be from any party. The seller can have a breach of the contract, or the buyer can have the breach of contract. So in both cases, we have seller's remedies as well as the buyer's remedies. Under the seller remedies, we have suit for price, suit for damages for non acceptance of goods, suit for interest, suit for damages for repudiation of contract. And under the buyer's remedies, suit for damages for non-delivery, suit for specific performance, suit for breach of warranty, for repudiation of the contract, and for interest. So let's read them in detail. Firstly, let's start with the buyer's remedies. Buyer's remedies, the first point is suit for damages for non-delivery. Means under section 757, the section implies that if the seller wrongfully neglects or willfully refuses to deliver the goods to the buyer, then the buyer has a remedy to suit for the damages for non-delivery. Means where the goods are readily available in the market, the buyer is entitled to get damages equal to difference between the contract price and the market price on the day of breach. This is the right of the buyer to sue for this amount, that is the difference between the contract price of the goods and the market price on the day of the breach. But when the goods are not readily market available, the measure of damages shall depend upon the facts of the case. Second remedy with the buyer is suit for specific performance under section 58. This section says that where the goods are specific or a certain goods and the seller neglects to deliver the goods, then the buyer may in special case obtain the permission from the court for the specific performance only. The buyer is not interested in the damages. The buyer can claim for the specific performance, and this can be allowed by the court in special cases. There, the court may compel the seller to perform the contract specifically instead of paying the damages for breach of contract. And the court may also order specific performance where compensation in money is not possible on buyer, means where with the compensation of money the buyer's loss of goods is not covered and buyer is not satisfied with the payment of damages. In that case, the court may order for the specific performance on the behalf of the buyer. Third buyer's remedy is breach suit for breach of warranty, section 59. The breach of condition, the breach of warranty we have studied in detail, and breach of condition justify the buyer in rejecting the goods. Means if any specific condition of the contract is not fulfilled by the seller, the buyer has the right to reject the goods, though he has option to treat the breach of condition as a breach of warranty, and in that case he can claim the damages of breach of warranty. Section 59 provides the following remedies in this case to the buyer. 1. He may set up against the seller the breach of warranty or extension of the price. Means if there is a breach of warranty, then the buyer can call for extinction of the price. Second, he may sue the seller for damages for breach of warranty. Next remedy is repudiation of contract before due date. Section 60 covers it, where in any case, if the seller has repudiated the contract before the date of delivery, then the buyer may exercise this right, and the buyer may treat the contract as subsisting and keep it alive till the date of delivery. Or the buyer has a right, he may treat the contract as rescinded and sue for damages for the breach of contract. And if in this case the buyer exercises his right to sue for damages for the breach, this would incorporate the rule of anticipatory breach of the contract. Means the remedies, the rules of the anticipatory breach would be applicable here. But when a party to contract refuses to perform his part before the actual time arrives, the law gives an option, either to resign the contract and sue for damages. Second, when the contract is not been resigned but the other party wants to treat it as still operative and can wait for the performance. Fifth is suit for interest under section 61. Where there is a breach of the contract by the seller, the price is to be refunded to the buyer. Means, let's suppose the buyer has paid the price in advance and the seller has not delivered the goods, then in that case the seller has to refund the price paid to the buyer. Then the buyer can also claim for the interest on the price paid to the seller, and this interest is to be run from the date on which the payment was made. Let's suppose the contract was done on the contract was done on 1st January and the buyer has paid the price of the goods on the same day, but the contract was to be performed on 1st February, and on 1st February the seller has not performed the contract. Because the price of the goods was paid on 1st January, the interest on that price is to be paid by the seller from 1st January. So now the buyer can only recover interest, but the buyer can only recover the interest when he is entitled to recover the actual price. But where he cannot recover the actual price, he cannot recover the interest, there he can only sue for the damages. We have discussed by now the buyer's remedies, and seller's remedies we have already discussed when we have discussed the rights of the unpaid seller. Now we move to the another topic, that is the auction sale. We must have listened this term in our routine life, auction. Now what is the meaning of auction and why it is important to discuss this topic here? And when we talk about the sales of goods, this is one of the sales which is very popular when we this is the auction sale. So what is the meaning of auction sale? One of the modes of the sale in public is the auction sale, when different buyers come to a particular place to purchase the goods, and goods are sold to that person who pay the highest price for a particular article. That is a auction sale, that is an auction sale. And what happened in the auction sale? The in auction sale, either the seller of the goods sell the goods themselves, or he can appoint an agent for the sale of the goods who is known as the auctioneer. And there is always an agency relationship between the auctioneer and the owner of the goods, means the person who is performing the task of selling the goods on the behalf of the seller. The person would be known as the auctioneer, and there would be the agency relationship between both of them. Reason being, the auctioneer is working as an agent for the seller. Now, how this auction sale is being done? What is the procedure of auction sale? Let's discuss that in detail. One, first of all, an advertisement is being given in the newspapers to sell the good of regarding the sale of the goods, and in the newspaper all the terms and conditions of the sale are also being advertised. Second, in the then the auctioneer, if the sale is to be done by the auctioneer, then the auctioneer is being appointed, and the auctioneer fixes the time and place of the sale where the goods would be sold. Then the intending buyers means the persons who are willing to take the delivery of the goods would come to a particular place for give their bids means they what are their intention to pay the price, means how much price they want to pay for the article, that is known as the bid. And this bid is being given during the process of auction sale. Now, on the fixed date and on the fixed place, the bidders come for their to offer their respective prices for that particular article for which the advertisement was made. And it's very interesting to know here when the how the sale is being completed. When the bidders give their bids, then the person who have given the highest bid is being taken by the auctioneer, and he loudly speaks what are the prices being offered. Like, let's say there is an article, there is an antique vase which the seller wants to say, and the person in a auction sale says it's for rupees 1 lakh, and another person says I am willing to pay 1,25,000. Then the auctioneer will loudly speak 1,25,000. That means it's an intimation to all the bidders sitting there. That means if any person wants to pay more than 1,25,000, the person can give his bid. Now, the bidder who wants to purchase the good, they can give the higher prices. Means in this example, the another bidder can go for 1,30,000, 1,40,000, 1,50,000, and so on. That means bidders go on offering more and more prices, and goods are sold to the person who will give the highest bid at the last. And this highest bid constitutes an offer to buy. This cannot be considered as a as an sale. This is always known as the offer to buy. And when at the last step in the auction sale, that is the fall of the hammer or any other customary announcement means the auctioneer can say कि at the saying of 3 the sale would be performed. That means 1, 2 and 3, this is a final announcement. Or he can the fall of the hammer would also decide that this is an acceptance of the offer by the auctioneer or to the highest bidder. This is clear from the case of M. Lachia Sethi versus Coffee Board. The court decided that the auctioneer is not bound to accept the highest bid. He may reserve the right to refuse any bid or to accept a lower bid in preference to a higher one. This case gives a very strange decision, that the normally we say that in case of auction sale, the person who gives the highest bid is being is able to buy the thing. But in case of this case, the court decided that it is not always that auctioneer is bound to accept the highest bid. That means the auctioneer can ignore the highest bid in some specific cases. He can refuse any bid and he can accept a lower bid in preference of a higher one too. Now, what are the rules regarding the auction sale? Section 64 says that one is the completion of auction sale. How when the auction sale is completed, as I said that when the auctioneer gives the fall of the hammer or says any customary words, there is a completion of auction sale. Let's see the example. A, an auctioneer offered to sell some furniture by auction. Various bidders attended the auction and B's bid, which was highest, was accepted by A by striking down the hammer on the table. In this case, the sale is complete as soon as the auctioneer strike down the hammer. Second, restriction of bid. Before the completion of sale, the bidder has right to withdraw his bid. Let's suppose one bidder has given the bid, like one has given the bid for rupees 1 lakh, another has given 1 lakh 25,000. But before 1 lakh 25,000 is being finalized for selling the article, every bidder has the right to withdraw his bid before the final sale, before the completion of sale. And this is based on the principle that the bid is an offer and it can always be revoked any time before its acceptance, as we have read in the topic of offer and acceptance. This is also clear within the case of Pine versus Cave. Let's see the details of the case. A, an auctioneer held a public auction for the sale of certain goods. B attended the auction and made the highest bid for the goods, but B withdrew his bid before the fall of the hammer. The auctioneer contended that there was a completed sale when B offered to purchase the goods by giving his bid. But it was held that B's bid was an offer and it could be revoked any time before the fall of the hammer. The crux of the case is there is always a right with the bidder that he can withdraw his bid before the fall of the hammer or before the saying of some customary words. That means before the completion of the sale, any time bidder can withdraw his bid. Third in this is the transfer of ownership. In case of auction of specific goods, once the hammer falls, there is a sale of specific goods. But if the goods are in the deliverable state and if the goods are the specific, the highest bidder becomes the owner of the goods and he can deal the goods at his own. This is clear from the case of Ganga Sagar Sugar Mills versus Rameshwar Das. The public auction was held for the sale of sugar bags of specified lot and number with which were in undeliverable state also. It was held by the court that the ownership passed to the highest bidder when the papers were completed after knocking down the process. So where the goods sold by auction are not of a specific nature, we have read the goods are of specific nature, but when they are not of specific nature and also not in a deliverable state, ownership will not pass to the buyer till the goods are knocked down to him, means till the goods are made in a specific form and goods are converted into a deliverable state. If the goods were not in a deliverable state, the court held that the ownership could not pass on the fall of the hammer. This is clear in the Consolidated Coffee Limited versus Coffee Board case. Next point under this is the seller's right to bid. As the buyer has the right to withdraw his bid, similarly seller has also the right to bid for the bid for the auction sale. Actually, what happens, sometimes seller has apprehensions that bidders may enter into a knockout agreement. Knockout agreement means the bidders can have an agreement between themselves so that the price of a good cannot be raised. They can give the low price biddings for with their mutual consent. So to avoid it, the seller may either bid himself or may appoint a person to bid on his behalf too. Here, if the seller appoints more than one bidders, then the auction sale becomes voidable, because in that case it is being known that the seller is pretending bidding to raise the price of the sale. So then if this is being found, it becomes voidable at the option of the buyer to get that article or not to get. This is clear from this example. An auctioneer held a public auction for the sale of a horse. It was notified that the seller or anyone person on his behalf may also bid. B attended the auction and made the highest bid of rupees 2000, which was accepted by A by the fall of his hammer. Later on, B came to know that seller had appointed three persons to bid on his behalf. Now it is at the option of the B to perform the contract or not. As said, the seller can appoint only one person or can bid himself. If he appoints more than one persons to bid in a auction sale, this auction sale becomes the voidable contract. Next point in this is a fraudulent sale. If the seller has not reserved his right to bid at the auction, he cannot bid at the auction. Means before the auction sale, before giving the bid in an auction sale, the seller has to reserve his right to bid at the auction, and he can also appoint any person for this reserve, for this right. And if he does so, the buyer may treat the sale as the fraudulent sale. Means if he don't reserve his right to the bid at the auction before the auction sale, the buyer may treat the whole contract as a fraudulent sale, and then he may refuse to take the delivery of goods sold to him. There is an example. An auctioneer held a public auction for the sale of certain carpets, and it was notified that seller has the right to bid at the auction. B attended the auction and made the highest bid. Subsequently, he came to know that one person was bidding on behalf of seller, so he can refuse to accept the carpet sold to him. Next point is auction sale with reserve of upset price. What is the meaning of reserve of upset price? Sometimes the seller is not willing to sell his articles, sell his goods less than a particular price. So he can fix a minimum price, he can fix a upset price for his goods. That means if this price is fixed, this would help him to protect himself against the knockout agreements. Like if say Mr. A wants to sell his antique vase, and he wants to sell it at a minimum price of rupees 1 lakh, he can make this a minimum price, make this an upset price. There are dual reasons. One, he don't want to sell the good less than that price. Second, he wants to protect himself from the knockout agreements of the bidders. So in this case, if the auctioneer don't want to accept any highest bid, if he is not willing, he can refuse it. In other words, we can say if any person gives the bid lower than the upset price, the auctioneer can always avoid that bid, because that is lower, that is minimum, that is less than the upset price. And if by mistake auctioneer knocks down the goods, means if he falls his hammer for the less than the reserve price, seller can refuse to deliver the goods to the buyer, because he has already given his consent, he has already given his mind to sell the goods on a minimum price, on an upset price. In short, if I conclude it, means if any seller don't want to sell any good below a certain price, he can set a minimum price, or in other words the upset price for that. And in that case, the auctioneer auctioneer is not bound to select the highest bid, means he would not give the goods at the price less than that specific mentioned price. And if the auctioneer by mistakes knocks down the goods to the buyer, even then seller has the right to refuse the delivery of the goods to the buyer. And when the no price minimum price is fixed by the seller, and the auctioneer is notified without any reserve price, this is called without reserve auction sale. And in that condition, auctioneer can sell the goods at the conditions he like. This is clear from the case of Coffee Board versus Famous Coffee and Tea Works. In an auction sale of coffee, one of the conditions was that the seller does not bind himself to accept the highest bid or any bid. He is not bound to assign any reason for his decision, and his decision shall be final. The condition was held valid. The court observed that it gave a right to the seller to accept any bid highest or the lowest. It conferred upon the seller and right to accept a lower bid in preference to a higher one. So this was the process of the auction sale. At last, let's read the implied warranties in an auction sale. There are implied warranties in the contract of auction sale. One, the auctioneer warrants his authority to sell the goods on the behalf of his principal. As I have already said, there is a relationship of agency between the principal and the auctioneer, means between the seller and the auctioneer. So here the auctioneer gives the warranty that he has the authority to sell the goods on the behalf of the principal. He also warrants that he knows of the no defect in the principal's title. That means the seller is the true owner of the goods. He don't have any defective title. Third, he warrants that the possession of goods would be given to purchaser against the payment of the price, means the the possession would be definitely transferred to the purchaser once he pay the requisite price of the goods. And last, he warrants the quiet possession of goods by the purchaser. So this is all about the auction sale. Let's summarize what we have discussed in today's lecture. We have discussed firstly what is the unpaid seller, who is the unpaid seller, what are the rights available with the unpaid seller, again against the goods and against the buyers personally. Then if any kind of breach of sale of contract is made either by seller or by buyer, that is being discussed. And at last, under the auction sale, we have discussed what is the auction sale, what is the process of auction sale, and what are the implied warranties involved in the auction sale at the part of the auctioneer. So this is complete with the lecture on the topic rights of unpaid seller. Thank you so much.